C. 1. Whenever a petition shall have been filed, in accordance with such regulations as may be prescribed by the Board, a. by an employee or group of employees, or any individual or labor organization acting in their behalf alleging that a substantial number of employees I wish to be represented for collective bargaining, and that their employer declines to recognize their representative as the representative defined in Section 9. A. or I assert that the individual or labor organization, which has been certified or is being currently recognized by their employer as the bargaining representative, is no longer a representative, as defined in Section 9. A. or B. by an employer, alleging that one or more individuals or labor organizations have presented to him a claim to be recognized as the representative defined in Section 9. A. The Board shall investigate such petition, and if it has reasonable cause to believe that a question of representation affecting commerce exists, shall provide for an appropriate hearing upon due notice. Such hearing may be conducted by an officer or employee of the regional office, who shall not make any recommendations with respect thereto. If the Board finds upon the record of such hearing that such a question of representation exists, it shall direct an election by secret ballot, and shall certify the results thereof. 2. In determining whether or not a question of representation affecting commerce exists, the same regulations and rules of decision shall apply irrespective of the identity of the persons filing the petition, or the kind of relief sought, and in no case shall the Board deny a labor organization a place on the ballot by reason of an order with respect to such labor organization, or its predecessor not issued in conformity with Section 10. C. 3. No election shall be directed in any bargaining unit or any subdivision within which, in the preceding 12-month period, a valid election shall have been held. Employees engaged in an economic strike, who are not entitled to reinstatement, shall be eligible to vote under such regulations as the Board shall find are consistent with the purposes and provisions of this Act, in any election conducted within 12 months after the commencement of the strike. In any election where none of the choices on the ballot receives a majority, a run-off shall be conducted, the ballot providing for a selection between the two choices receiving the largest and second largest number of valid votes cast in the election. 4. Nothing in this section shall be construed to prohibit the waiving of hearings by stipulation for the purpose of a consent election in conformity with regulations and rules of decision of the Board. 5. In determining whether a unit is appropriate for the purposes specified in subsection B, the extent to which the employees have organized shall not be controlling. D. Whenever an order of the Board made pursuant to Section 10. C. is based in whole or in part upon facts certified following an investigation pursuant to subsection C of this section, and there is a petition for the enforcement or review of such order, such certification, and the record of such investigation shall be included in the transcript of the entire record required to be filed under Section 10(e) or 10(f), and thereupon the decree of the court enforcing, modifying, or setting aside in whole or in part the order of the Board shall be made and entered upon the pleadings, testimony, and proceedings set forth in such transcript. 1. Upon the filing with the Board, by 30% or more of the employees in a bargaining unit covered by an agreement between their employer and labor organization made pursuant to Section 8(a)(3) of a petition alleging they desire that such authorization be rescinded, the Board shall take a secret ballot of the employees in such unit and certify the results thereof to such labor organization and to the employer. 2. No election shall be conducted pursuant to this subsection in any bargaining unit or any subdivision within which, in the preceding 12-month period, a valid election shall have been held. Prevention of unfair labor practices. Section 10. A. The Board is empowered, as hereinafter provided, to prevent any person from engaging in any unfair labor practice listed in Section 8, affecting commerce. This power shall not be affected by any other means of adjustment or prevention that has been or may be established by agreement, law, or otherwise, provided that the Board is empowered by agreement with any agency of any state or territory to see to such agency jurisdiction over any cases in any industry other than mining, manufacturing, communications, and transportation, except where predominantly local in character, even though such cases may involve labor disputes affecting commerce. Unless the provision of the state or territorial statute applicable to the determination of such cases by such agency is inconsistent with the corresponding provision of this Act, or has received a construction inconsistent therewith. B. whenever it is charged that any person has engaged in or is engaging in any such unfair labor practice, the board, or any agent or agency designated by the board for such purposes, shall have power to issue and cause to be served upon such person a complaint stating the charges in that respect and containing a notice of hearing before the board, or a member thereof, or before a designated agent or agency, at a place therein fixed, not less than 5 days after the serving of said complaint, provided that no complaint shall issue based upon any unfair labor practice occurring more than 6 months prior to the filing of the charge with the board, and the service of a copy thereof upon the person against whom such charge is made, unless the person aggrieved thereby was prevented from filing such charge by reason of service in the armed forces, in which event the 6-month period shall be computed from the day of his discharge. Any such complaint may be amended by the member, agent, or agency conducting the hearing, or the board, in its discretion at any time prior to the issuance of an order based thereon. The person so complained of shall have the right to file an answer to the original or amended complaint and to appear in person, or otherwise, and give testimony at the place and time fixed in the complaint, in the discretion of the member, agent, or agency conducting the hearing, or the board. Any other person may be allowed to intervene in the said proceeding, and to present testimony. Any such proceeding shall, so far as practicable, be conducted in accordance with the rules of evidence applicable in the District Courts of the United States, under the Rules of Civil Procedure for the District Courts of the United States, adopted by the Supreme Court of the United States pursuant to Section 2072 of Title 28, United States Code. C. The testimony taken by such member, agent, or agency, or the board shall be reduced to writing, and filed with the board. Thereafter, in its discretion, the board upon notice may take further testimony, or hear argument. If upon the preponderance of the testimony taken the board shall be of the opinion that any person named in the complaint has engaged in, or is engaging in any such unfair labor practice, then the board shall state its findings of fact, and shall issue and cause to be served on such person an order requiring such person to cease and desist from such unfair labor practice, and to take such affirmative action including reinstatement of employees with or without back pay, as will effectuate the policies of this act. Provided that where an order directs reinstatement of an employee, back pay may be required of the employer or labor organization, as the case may be, responsible for the discrimination suffered by him, and provided further that, in determining whether a complaint shall issue alleging a violation of Section 8A1 or Section 8A2, and in deciding such cases, the same regulations and rules of decision shall apply irrespective of whether or not the labor organization affected is affiliated with a labor organization national or international in scope. Such order may further require such person to make reports from time to time showing the extent to which it has complied with the order. If upon the preponderance of the testimony taken the board shall not be of the opinion that the person named in the complaint has engaged in, or is engaging in any such unfair labor practice, then the board shall state its findings of fact, and shall issue an order dismissing the said complaint. No order of the board shall require the reinstatement of any individual, as an employee, who has been suspended or discharged, or the payment to him of any back pay, if such individual was suspended or discharged for cause. In case the evidence is presented before a member of the board, or before an administrative law judge or judges thereof, such member, or such judge or judges, as the case may be, shall issue and cause to be served on the parties to the proceeding a proposed report, together with a recommended order, which shall be filed with the board, and if no exceptions are filed within 20 days after service thereof upon such parties, or within such further period as the board may authorize, such recommended order shall become the order of the board, and become effective as therein prescribed.